Welcome to the PI Show, viewers. This is a show where we talk about all aspects of personal injury law and how it relates to you, the viewers. My name is Nunzio Tartaglia and I'll be standing in for Tony Carbone, who's taking a well-earned break. With me tonight, I've got John Karantzis, who is a partner at an insurance law firm in Melbourne.
Hi Nunzio, hi viewers.
And Jessica Rosla, who is a lawyer in the insurance department in Melbourne also.
Evening Nunzio, evening viewers.
Tonight we're looking at medical negligence cases and we have 4 or 5 different interesting cases that we can chat about later. But
However, before we get to that, Nunzio, what's in the news?
First one, we've got a really sad case, that of the toddler that's crushed by a television. Jess, can you tell the viewers a bit about that one?
Yeah, certainly, Nun. So, unfortunately, as you said, it was a very tragic case where a toddler had a habit of climbing up onto a TV cabinet, which was not mounted to the wall. Her mum had stepped out of the room for about 5 minutes or so, and unfortunately when she came back, as it turns out, the TV had collapsed onto the toddler, causing a tragic
So we've got
death.
a situation where the toddler's really pulled the TV onto her,
That's what
watching
it
her
would
favourite
seem.
cartoon.
Yeah.
Yeah, we used to hear this quite often, Nunzio, didn't we? But not as much anymore.
Well, you know, technology's changed and most TVs are mounted and the like. So,
Yeah.
but I suppose, Jess, my question would be, you know, the parents are saying that you know it wasn't secured to the wall. They weren't told to do so, but at the same time they didn't read the manual. If they were to pursue a case, do you think they have some viability there?
I think it's difficult, Nunzio, and you raised the 2 relevant points that will be contested if they were to bring a case. So one is the warning by the manufacturer in the manual that it's preferable for the TV to be mounted, and the second is the parent's knowledge of the toddler's propensity to climb the wall. So it's a balancing exercise that the court will have to undertake.
And also, I guess, well, the person selling the TV, do they have any responsibility in advising the family, especially if they know that, there's a young child involved, that you should have this TV mounted on the wall? Otherwise, it may fall on the child.
Look, I think all aspects of the purchase would have to be investigated and see what comes of it. But look, it's just a lesson to all at home. Just be careful because tragic circumstance like that can occur. Next case is that of a suspension for a midwife due to a home birth. Jess, do you want to tell the viewers a little bit about what happened there?
Yeah, certainly. So we spoke about this some episodes ago where the midwife involved had, unfortunately, circumstances occurred whereby there was a delay in calling an ambulance when the mother was in distress during a home birth. And as it turns out, the child was unfortunately stillborn and an emergency caesarean had to occur. She's subsequently been reprimanded by VCAT and various orders have been made restricting her practice into the future.
Well, she's admitted, and the midwife's name is Nicola Dudden. She's admitted to misconduct and has been suspended for 6 months, professional misconduct over the botched home birth, Nunzio.
Yeah, look, and 6 months actually seemed a little bit light.
Very light.
To be honest with you, in light of the outcome.
Someone's died.
Yeah, and it looks like she's also got to work under supervision for 2 years. So look, her trying to get back though, it's a pretty big penalty in one way. But look, it's just a lesson that these home births come with risks, don't they, Jess?
Definitely. And the other factor we raised in our previous episode was that there were questions about whether these midwives are actually insured, which makes it very difficult for parents in that situation seeking any kind of recourse.
So why would you do it?
Yeah.
Why would you do it? And in this case, it was a failure to advise or discuss as to the possible risks involved.
Yeah.
It's ludicrous.
And what's worse, when she needs to be referred to the hospital, she
Yeah.
effectively didn't do it in a timely manner, and that's scary, as you said. So, but look,
it's very
I think I think we spoke about the prospects of the case. I think it's got a little bit stronger with this outcome, don't you think?
I would agree. Yeah.
The next one's really disappointing. We spoke about this article, or would have been about a month ago, where St Vincent's Hospital in Sydney admitted to the fact that there'd been incorrect dosages of with respect to its chemotherapy. However, at the time, they made a statement saying that hadn't really made a big impact, and they don't think there's any major consequences flowing from that. But they've done a whole role reversal, John.
Well, it's emerged he gave incorrect doses of chemotherapy to 78 people, and this is an oncologist by the name of John Griggle. It's shocking.
And what's worse, though, at the time when they made the statement, they said effectively there wasn't really many deaths or minimal.
That's
And it's
right.
come out as 23 deaths.
Yeah.
So this investigation, thankfully, now is widening.
Yeah, that's right. So touching on what you said, Nunzio, the statement released also referred to the fact that any relapses that had occurred were within the normal rates of relapse. But it appears now that with this further investigation, there could be a link between the low doses and the relapse and subsequent deaths.
So this is akin to a class action against the St Vincent's Hospital in Sydney.
Well, look, yeah. Initially, they've painted it as Dr. Greigel being the big issue, but I think they're both now, because the fact that St Vincent's Hospital, I don't want to say cover up, but the fact is it made a public statement saying that there was no negative impacts, and now there's 23 deaths.
Yeah.
So it really concerns me. So this really could go on for quite some time.
And he had worked at the St Vincent's in Sydney from 2006. He was there for quite a long time. So
And that's why the investigation's now going to date back to them, thankfully. So
you have
people
the
get some
issue
answers.
of supervision or lack thereof.
That's right.
Yeah.
Okay, Jess, so this is the article about a boy's, I suppose, need for chemotherapy and the parents' desire not to go ahead with it.
That's right, Nunzio. So in this case, a 6-year-old boy had been diagnosed with a brain tumour. The parents ultimately elected against chemotherapy and radiotherapy treatment. The staff at the hospital, which is the Princess Margaret Hospital, made an application to the court to have that decision effectively put aside and make an order, and receive an order that the child receive treatment, and were ultimately successful. There's questions about whether the parents will appeal that decision now, Nunzio.
Nunzio, it's a question of what is in the best interests of the child. The court, that's the only focus on the court, and the parents' wishes were totally overruled. We just hope that the medical treatment will actually work, will actually be in the best interests.
Look, they say 30% chance, and look, I think it's the right decision, because we're not talking, it's a no to no hope. It's not a one in, a million chance.
No.
So, look, I'm sort of glad that the court's overruled in this instance, but also it's a fine line between, the parents losing power generally, if that makes
Yes.
sense. So
Yeah.
we've got to be careful in that regard.
Oh, yes.
Just quickly before we head to the break, John, this is the article about the class photo blackout.
Yes, it's an interesting article. It seems that there's all these private schools involved. Basically, in grade 5 or 6, for example, they're telling their students, you can't put these photos, as in of your classmates, on social media.
Facebook, all that kind
Yes.
of, all that kind of jazz. Look,
Yes.
they're trying to obviously, clamp down on, any bullying and cyberbullying, all that kind of situations. And look, it's another level. I didn't think it'd go that far, but they clearly have. So
Isn't it a bit too late now?
could be
Facebook and Instagram, that's all out there now.
Yeah.
You can't stop it.
True. I'm sure we'll hear more about that. But after the break, we've got interesting Med cases to talk about with you. Welcome back from the break, viewers. Tonight we have an interesting episode on medical negligence and have 4 cases to discuss with you. And look, as we've previously said on the show, medical negligence is a very complex and detailed area of law. And look, these cases are a prime example of that, but we'll try and make it as interesting as possible for you. But the first case tonight we have is that of Wallace and Cam, Jess. Do you want to tell the viewers a bit about the facts of that?
Yep, certainly. So this case, viewers, is a High Court of Australia case, which is the highest court in Australia, as the name would suggest. It's what we define a failure to warn case. So basically what occurred, viewers, is that Mr. Wallace had gone in for lumbar spine surgery, and that the nature of that surgery carried with it a number of inherent risks. 2 of those risks were that of bilateral femoral neuropraxia, which is basically nerve damage to the thighs as a result of lying face down for an extended period of time. and the second was catastrophic paralysis. The questions that arose were whether or not the surgeon in question had warned Mr. Wallace of these risks. And in this case, as it turns out, the first risk, which is that of bilateral femoral neuropraxia, had materialised, meaning Mr. Wallace came out of the surgery having developed that condition, but the second risk did not. Ultimately, at first instance, the court found that the surgeon had negligently failed to warn Mr. Wallace of those risks, and the key question in dispute was whether or not that had actually been a cause of his symptoms.
Jess, the surgery was unsuccessful.
That's correct.
He suffered the paralysis to his leg.
Yep.
And that continued, and he's issued proceedings claiming that injury and
That's
claiming
right.
also that of the failure to warn.
That's right.
Okay, and the High Court considered the judgment at first instance, which was in favour of the defendant.
That's right.
It was a split decision, wasn't it?
Yeah, the Court of Appeal decision was split, and the High Court decision preferred the majority effectively, which was against the plaintiff. But the key issue in dispute was the finding that had the plaintiff been warned of the neuropraxia, he still would have gone ahead with the surgery. And that's really where the case struggled, John and Nunzio.
So in this case, effectively, look, it was clearly, I think, all levels of the decision, Court of Appeal, High Court, they were torn because, as I said, there's no unanimous decisions, and I think rightfully so when you read the decision. But effectively, so the scenario, if he obviously wasn't warned about it, but his evidence would have been, I wouldn't have undertaken the surgery, he would have been successful. Is that correct?
Yes, that's right.
Okay, so the fact that he wouldn't have, basically the defendant was trying to allege that you really can't be compensated for something you've accepted the risk for.
That's exactly right.
Yeah. What do you think about that, John?
Oh, look, it's very logical. I've got no inherent problem with that, Nunzio. No. I guess the issue is when you've undertaken, surgery, and here he's alleging that there's a failure to warn of any risks, at the same time, the patient, Mr. Wallace, is admitting, that in any event, if I was advised as to the neuroplaxia, I still would have gone ahead with it. Well, then, fair enough. That's the risk you take.
Look, I think, to be frank, I think it was clever lawyering because his lawyers obviously have latched on to one of those risks and said, well, this is an angle to try and obtain compensation. Look, and rightfully so, I think that's what you do. And that's why this area is so complicated because you need to go through all those different degrees of evidence.
Yeah.
It'd be a different or interesting result if, let's say, he didn't suffer the neuroplaxia, but he suffers paralysis.
I think he would have won.
He would have won, wouldn't he?
Because it said that he didn't accept that risk.
Yeah, and the other aspect, the court made noises about the reasons why we have these policies in place, which is effectively equipping the patient with knowledge so that they can make an informed choice. And as you said, John, the patient may be prepared to accept one risk and not another. And in this case, as you said, Nunzio, clever lawyering required that they had challenged not warning of one risk and whether it caused a different risk. And the court said that there's equal policies in place to protect the doctor's, what we call, scope of liability. So ultimately, the case fell away on that ground. But
it's very unusual that there were no warnings at all.
Yeah, look, I said, and that's, a big issue when it comes to these medical negligence cases. Generally, you'll get doctors or surgeons give you, disclaimers saying, I've advised you of the risks, the warnings, and all those situations. But in this case, it seems like the doctor was silent on a lot of these things, and they were big risks.
Yeah,
like paralysis.
Right. Yeah.
Because a lot of times the issue is the extent of the warning.
Exactly
Was
right.
the warning
sufficient?
That's right.
And look, and that's just a lesson to viewers. Look, when you are undertaking surgery, you've got to speak to your doctor throughout all these the potential situations so you can make an informed decision. And and those that not, you need to go see a lawyer because it's a complicated area and one that we can try and assist you with.
And Nunzio and Jess, you're both experts in medical negligence. Someone faced with a surgical procedure that's gone wrong, what would your advice be?
Well, look, we have to go through, from the time you walk into the surgeon's rooms to the time you've had the surgery and the like, because it's so complicated, John, and that's why you need to get the records. You need to, obviously there's means of interrogating the defendant. So it's a complicated and one that you need legal advice.
And they should ring you, shouldn't they?
Yeah, look, you got to call Nelkie Carbone on 1300 injured. We're always there to help in that regard. So anything to add on that, Jess?
No, that's right, Nunzio. And I guess the other aspect is there's a lot of questions about what's called admissibility of evidence. So whether certain things can actually be used to support the plaintiff's claim, hence why it is important to obtain legal advice about these matters.
Well, while we're on admissibility of evidence, we're going to our next case, which is that of Tinnick v Murrumbidgee Local Health District. It's regarding what experts you can and can't use, John. And in medical negligence, you've got experts for every different area of law. It's not like just getting a general surgeon to give comment. What was this case really concerning, just in a nutshell?
Nunzio, the admissibility of, in this case, a surgeon and whether or not his evidence can be presented to court. Now, the defendant alleged were of the view that, no, he is not an expert. And you've got these, a lot of these cases, especially Makita in the New South Wales Court of Appeal, that gives a criterion of who is an expert. And I think you and I have both seen mini hearings within a hearing that take a day or so for the judge to work out, well, is this guy an expert? In this case, the court summarised basically that, well, he's a surgeon, and he's giving an expert view on the facts involved. I think he's an expert.
Well, look, we'll talk a bit more about that after the break, so stay tuned and we'll be back soon. Welcome back, viewers. Before the break, we were speaking about the case of Tinnick and effectively expert evidence, or the admissibility of it. Now, Jess, in this case, it was interesting because the expert in this case wasn't briefed, if that's the right word, to comment upon liability or fault.
Right.
It was more sort of briefed to comment upon the extent of the injury.
Yep.
But it's morphed into it being a liability report.
Yeah, that's right, Nunzio. And I think it was perhaps a product of the nature of the surgery and perhaps the surgeon noting the extent of the plaintiff's injuries and wanting to draw on that. But effectively, as John was saying, the key questions were whether or not the expert was qualified to express a view in relation to these factors. So the expert in question was a plastic and reconstructive surgeon, and the questions about liability and the cause of the injuries related to infection. And effectively, the court summarised three main points that they need to assess as to whether or not the evidence is admissible, which means allowed and in support of the case or as to the matters relevant to the case. And they were whether or not the evidence is relevant, whether or not the expert has a specialised expertise, and whether the opinions made were based on that specialist expertise.
Look, and that's, again, another reason why medical negligence is complicated, because as I said, you've got, sometimes you can be in error because you get the wrong expert. You think you've got a general surgeon giving you a great comment, but then the court's going to say, no, you can't use that.
Especially when it's not their specialised field of knowledge.
Yeah, and there's so many different varieties. But look, we'll get back to those issues anyway. Next case, John, of Dallas versus McMahon. It's an interesting case of, can you issue proceedings twice for, arguably the same injury?
Yes. Here, it's a New South Wales Supreme Court Court of Appeal decision. Very interesting factual matrix. There's been a motor vehicle accident. A claim for compensation is made. Damages are awarded.
I think $335,000.
Exactly.
Yeah.
Now, as a byproduct of the injuries, doctors have performed surgery rectifying the medical condition arising out of the transport accident, and that's where the problem arises. There's a bit of medical negligence arises. There's now a claim for medical negligence against the doctors, and the issue here is, well, you've already been compensated once for the transport accident injuries. How can you now be compensated again for this in relation to the same injuries, but in relation to medical negligence?
Exactly right. So, just do you want to explain why this is sort of turned into a medical negligence case as well? What's the negligence per se?
Yeah, certainly. So the actual negligence was a misdiagnosis. Yep. So effectively, the primary injuries, if you like, were that of the neck, right shoulder, right arm, and right foot. And the plaintiff then alleged that as a result of that right foot injury, developed issues with the left foot, which is quite common, John and Nunzio, I think we'd say, with those kind of injuries. And subsequently, there was a misdiagnosis of DVT, whereas the actual injury was that of a left calf torn muscle. And treatment was had, which has then caused some further complications. So the key questions at trial or on appeal were whether or not the plaintiff had already received compensation for the left leg injury as a product of the motor vehicle accident damages, or whether or not it's a discrete injury and the doctor's negligence has effectively broken.
So look, the court, in terms of the decision, haven't really answered. They've said, look, we'll go to a full trial. You have to hear the evidence. They haven't knocked it out because there was a summary application to say it should be dismissed.
Yes.
So, they're not saying no, they're not saying yes. But, John...
They are allowing...
a chance to get
the claim to proceed on the basis that, or the first proceeding, whereby Ms. Deluz received a compensation for the transport accident, did not extinguish the claim for medical negligence.
I think this opens up a can of worms because, look, she's claimed left leg injury in a motor vehicle accident claim. She's been compensated. We don't know the extent to which that compensation attributed to that. But where does it stop?
I have to admit, I was surprised by the decision. I expected to read at the end that the claim will be dismissed on the basis that you've received compensation once. You can't receive it again for what's tantamount the same injuries. However, the court has distinguished that you receive compensation for the transport accident. Here, your claim is in medical negligence. The medical negligence question and claim was not considered in the transport accident. So it's interesting.
I think what has helped the plaintiff in this case is that there was a report from one of the medico-legal doctors who said the left leg injury is not causative of the MVA or the motor vehicle accident. So, did they really even get compensated for it?
Yeah, there's that aspect, Nunzio, and the other point the court raised was the motor vehicle accident proceeding didn't actually determine to what extent that the motor vehicle accident caused the left leg injury. So it's left open that question.
But no case does, Jess and John. The fact is we settle, we resolve cases on a, confidential basis, and in the terms of the release you don't really define we paid you X, Y and Z for that.
So what we can take from that is if this actually had gone to a full-blown hearing and all the issues were dealt with by the court in the transport accident claim, it may have been a different story then.
I agree.
But you got the issue of promissory estoppel and res judicata, whereby that hasn't occurred, and therefore the court's saying, well, actually no, that hasn't been explored by a court, so it can be in the second instance.
We'll see what comes out of that one.
Yes.
Just quickly before we wrap up, Jess, the case of Francis v. Petros, which is a WA decision, can you explain just quickly to the viewers the importance of this case and how it more relates to Victorian claims?
Yeah, certainly. So effectively, just a short summary of the facts was that the plaintiff underwent surgery in the year 2000 and ultimately the damage that occurred from that surgery only crystallised in 2007. Proceedings were subsequently issued in 2008. The key aspects in dispute was how long the plaintiff had to issue those proceedings. And during the course of that 8-year period, there were two different acts in place, one of which said the plaintiff had 6 years, one of which said the plaintiff had 3 years to bring proceedings. The initial application was that the defendant was successful in having the matter struck out, which highlights the importance of consulting with a lawyer early.
See a lawyer, ASAP.
And ultimately, thankfully, the plaintiff was successful on appeal of that decision. But again, it's very important to move quickly and seek advice.
So here, the issue is, when did the injury arise? Causation.
Correct. Yeah.
And the defendant was saying it arose at the date of surgery.
That's right.
2000.
But that's not necessarily the case.
Yeah.
In this case, the plaintiff was saying 2007 or 8 when, effectively said the injury came to fruition.
He's pretty lucky. The judge has allowed him to explore that issue.
Well, look, and that's why these cases are important, and you need to get legal advice because you've got to, in Victoria, 3-year time frame, really.
Very strict.
And it's fairly strict, with really very little exception. But look, that's all we've got time for tonight, guys. Thanks, John,
Thank you,
Jess,
Nunzio.
for your time. Viewers, I hope you enjoyed the show. Please go to our past episodes. Please go to our social platforms and stay tuned for next week.